The NCAT board was asked for proof of their statements and to revoke the document if it was incorrect. They did not have any proof of the claims. They refused to revoke the resolution and stood behind the same document despite its errors.
Krueger says we didn't provide proof. I think he's referring to my reply to his attorney's October 13 letter. That letter asked me for evidence in support of unspecified statements in the NCAT resolution. And when asked to clarify which statements, the attorney declined to do so. I therefore referred him to ProPublica.org for Matt's IRS Form 990s and Matt for most everything else, and provided him with evidence that Krueger had destroyed evidence. Here's the lawyer's letter asking for documentary evidence. Here's where I refer him to ProPublica.org for the Form 990s. Here's where I refer him to Matt for most everything else. Here's where I point out that he already has Krueger and Burdorf's lawsuit against Miller since he's one of the attorneys litigating that case. And here's the 3 PDFs I sent him that constitute evidence that Krueger destroyed evidence. The first evidence cited in the NCAT resolution. Here's Krueger's LinkedIn page as it appeared on September 4th, 2022. Here's where that page said that Krueger had a demonstrated history of management of nonprofits. We used his statement in the NCAT resolution to show that Krueger should know all about the Form 990s that nonprofits must file with the IRS. In reality, it may be that this demonstrated history statement is false, and that because of its falsity, the LinkedIn page went missing. Here's where the same LinkedIn page says that Krueger started working at Matt in March of 2021. Here's where Matt's Contact Us page says that Krueger has never worked for a nonprofit before. The NCAT resolution was sent to Matt on September 14. By September 18, Krueger's LinkedIn page was missing. But it was still present in Google's search results on September 18, there at the top, even though the page could no longer be found.
They then tried to have the town officers in Norman County stand behind them in a meeting in the fall of 2022. We are aware that the town officers there did not issue any statement of support to them, nor did they feel they could revoke the document passed by those 5 men. Again, today they are trying to make all of you part of their dispute, but Matt does not have any dispute with any other township in Norman County.
Krueger asserts that Matt doesn't have any dispute with any other townships. But since he's already admitted that the 5 townships haven't done anything wrong, he's already admitted that Matt doesn't have any disputes with the 5 townships either.
In November 2022, I had a conversation with Mr. Gorder about how to resolve this dispute. I told Mr. Gorder that Mr. Pickle rejected Mr. Fenske's solution to form a joint power. As a joint power, NCAT would then be able to get insurance from Matt.
Let's look in detail at the joint powers option. Only concentrating on the joint powers issue ignores how NCAT also requested guidance on how to properly and legally operate. For example, in January 2022 and later, I asked Matt whether NCAT was supposed to issue W-2s or 1099s, and whether as an unincorporated nonprofit association, NCAT had to file a Form 990 with the IRS. While there was one attempt to answer the first question, the second question, there's been no response to that question. Also, Fenske opposed advertising the issue about the joint powers option, which meant keeping county unit directors in the dark that their personal assets might be at risk because the county units aren't insured. Here's Fenske's March 25, 2020 email to me. Here's where he argues against county units becoming governmental entities. Here's Fenske's April 12, 2022 memo about the county units. The cease and desist letter said that we should never have seen this document. The first red box is where Fenske says that Matt should not advertise the issue. Then he gets into the joint powers entity option. 4 pros versus 5 cons. 50 words in favor versus 114 words against it. It is obvious that Fenske thinks that county units forming a joint powers is not a good idea. Here Fenske's September 4th, 2020 email sent to the board on September 12th, 2022. 3 pros versus 7 cons. 27 words in favor versus 124 words opposed. Here's Fenske's December 28, 2020 email to me about the time I figured out that NCAT was an unincorporated association. And here's a close-up of Fenske's discussion in that email about becoming a joint powers and the problems with that approach. There are 7 sentences pointing out problems and complexities with that approach, excluding the sentence about minutes, and only 1 sentence showing a benefit to that approach. All this when all we needed to do was update NCAT's bank account. And yet, telling the IRS and the bank that we were an unincorporated association eventually resolved the entire problem.
Mr. Gorder seemed open to that option. He told me he was excluding Mr. Pickle from our conversation, that Messrs. Gorder, Werpy, Matthew, and Lee did not want to come to blows with Matt. He said the people we represent did not want it to get this far. We just want to resolve this so our county unit can be a government entity so we can get insurance. I did not sign up for Bob to go into this depth. It was obvious that Mr. Gorder regretted signing the resolution but still refused to apologize.
This is how Randy remembers that phone call with Krueger. Krueger said I had to be excluded, not Randy. Note the last item on the list. Randy did not regret signing the resolution.
3 days later, in a meeting between several of our staff and directors in November, 4 of these men admitted they did not know any of the allegations they made were true, but they made them anyways. Even when told the allegations were not true, they refused to revoke their document or apologize until Matt provided them with solutions they liked for the county unit.
What meeting is Krueger referring to? On November 7, town officers recommended that we reduce the issues to just the county unit question and see if Matt would assist us on that one issue. Randy then called Krueger. A Zoom meeting was set up for November 11. It was at that meeting that Krueger says the other NCAT directors said they didn't know whether any of the allegations were true. But the other NCAT directors deny saying any such thing. They weren't going to admit or sign anything in the November 11 Zoom meeting because they thought Krueger, Fenske, and Burdorf might try to pull off some sort of sheanigan.
They then made further offensive statements to individuals on our staff to deflect from their wrongdoing in that meeting.
What is Krueger referring to? The only thing I can figure out is that he was referring to Matt trying to trick the other NCAT directors into signing a document that might have provided a basis for them to be sued for defamation or defamation per se. Here we have the draft resolution Fenske wanted them to sign. The document properties say that Fenske created this document. The first and third highlighted spots, referring to criminal acts and injured reputations in their professional capacities, seem to me to be an attempt to establish defamation per se, which would give the plaintiff some advantages he wouldn't have if it were just defamation. The second highlighted spot, saying the statements were published, is a legalese way of saying they were repeated to someone else. The fourth spot refers to revoking the resolution in its entirety, which is unnecessary. One could just revoke the parts that are wrong. The fifth spot is very problematic. The average person would apologize for saying something they didn't know was false. But this pseudo-apology says the resolution was passed without knowing it was true. Why? When suing someone for defamation, you may have to prove that the person was negligent or reckless, and proving they said what they said without knowing whether it was true or false does that. The last spot is an outright lie. Matt has never provided evidence that refutes all the facts in the NCAT resolution. Randy asked Fenske how signing the pseudo-apology would affect him. Fenske refused to say on the grounds that he was Matt's lawyer, not Randy's. Yet Fenske's job is to provide legal information to town officers that ask questions. He therefore could have explained to Randy how the pseudo-apology would have provided a basis for Randy to be sued. But Fenske has a conflict of interest, since 30% of the resolution's facts section discussed him, and 60% of Matt's cease and desist letter was about him.
We have tried to resolve their issues through many communications and efforts, but Matt will not continue relationships that are harmful to Matt, the staff, and its directors. Given their behavior, we do not believe they have any good faith intent to work with Matt. Mr. Pickle has written numerous emails to myself, staff, and directors. He has written a complaint letter to the Office of Administrative Hearings accusing Matt of election tampering. He has restated accusations that are subject of a current defamation lawsuit against another person.
I think it's a bit odd that Krueger would fault me for repeating the allegations found in his and Burdorf's lawsuit against Miller. Why is that? Because he and Burdorf repeated the allegations in their lawsuit's complaint, that they then made a part of the public court record. That's before I can find any record of my repeating them. If they didn't want the allegations repeated by anyone other than themselves, they should never have put them in their lawsuit. But concentrating on such a thing evades the real issues. The NCAT resolution nowhere says that the allegations are correct. The real issues are that Burdorf told the Matt and Matt at Treasurer to quit asking questions. The Treasurer had recently investigated some financial allegations. Then there's the problem of the lawsuit essentially being barred by Matt's complaint policy, and the problem of 501c3 Matt paying for Krueger and Burdorf's private, personal, legal expenses. Here's page 1 of Krueger and Burdorf's lawsuit against Miller. Here's page 2 where Krueger and Burdorf repeated the allegations. Here's Miller's June 2nd version of his complaint that he filed according to company policy. Here's where Miller attached Burdorf's email telling the Matt at Treasurer to quit asking so many questions. Here's page 1 of Matt's complaint policy that existed when Miller filed his complaint on May 20th and June 2nd. Here's the part of that complaint policy that forbids retaliation. In other words, I think that when Krueger sued Miller, he should have been promptly terminated for violating Matt's promise of no retaliation against Miller, and Burdorf should have been removed from the Matt board. Such conduct should not be tolerated at all. Here's the July 21 board minutes. Here's the portion of the minutes approving Matt's payment of Krueger and Burdorf's personal private legal expenses after that board meeting reconvened on August 19. As of March 2023, it sounds as if the expense to Matt may be averaging $5,000 a month. Think that is just fine and dandy? Then ask your town board to buy you a new pickup titled in your name. Ask your town board to put a new roof on your house. Get the picture? This is a no-no. If Matt had sued Miller, then whatever proceeds would come from the suit would go to Matt. But Krueger and Burdorf sued Miller as individuals, and any proceeds would go into their own pockets. It is no more kosher for Matt to pay for these expenses than for my town board to buy me a new truck.